Hello, everyone. Welcome to week 3. And in this lecture podcast, I talk about the law of treaties. In the past 2 weeks, I had mentioned that one of the most important sources of international law would actually be treaties. And we know from Article 38, Paragraph 1 of the International Court of Justice statute that one of the key sources of international law would be treaties apart from customary international law and general principles of international law. The advantage of treaties being a source of obligations is that it is something that is easy for two states to enter into. So states could enter into a treaty about how to govern international passenger flights. It could be about international shipping. It could be about illegal and maybe unregulated fishing. It could be about the need to speak of biological diversity. And so the advantage of treaties is that two states or even more states can just agree to arrive at, to execute a treaty and develop their respective sources of obligation on the basis of a treaty by mere agreement of the parties. And so therefore, we now know that one of the most important sources of international law would be treaties because of the ease by which states could enter into international law obligations, as opposed, for example, to customary international law, which from what we learned in week 2, can take a while, mainly because for example, to be customary international law, you need the constant and regular practice of states, and with the understanding that what the states are practicing is actually regarded as binding on them. And so therefore, it takes a while for customary international law to emerge. On the other hand, as I pointed out, two or more states can just agree to enter into a treaty. And so therefore, it is important for us to know what exactly then is a treaty. And for example, is it necessary for an agreement to be in writing for it to become a treaty under, for example, the Vienna Convention on the Law of Treaties? And what happens if there is an international agreement and it is an international agreement that is entered into between a state and perhaps an international organization? Would that be considered a treaty? And is it necessary for a written instrument, for example, to be labeled or denominated as a treaty for it to be considered a treaty under international law or under the Vienna Convention on the Law of Treaties? And assuming that we have a treaty considered to be a treaty on international law, under what instances may parties, for example, avoid their obligations under a treaty? And so these are things that, these are issues that we will cover in this lecture podcast on the law of treaties. So after studying this topic, you should be able to discuss and explain the importance and nature of treaties, the rules that govern the various aspects of a treaty, the key provisions of the Vienna Convention on the Law of Treaties, and how states may enter into, avoid, and terminate treaty obligations. So how exactly is a treaty defined under the 1969 Vienna Convention on the Law of Treaties? So according to that particular convention, a treaty is an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments and whatever its particular designation. So if we examine Article 2 of the 1969 Vienna Convention on the Law of Treaties, you will notice that there are at least 4 key elements in order for a treaty under the Vienna Convention on the Law of Treaties to have been concluded. One is that it has to be an international agreement. 2, it must be concluded between states. 3, it must be in written form, and it has to be governed by international law. So what this tells us is that if you can have an international agreement, but it might not be concluded between states. It could be between international organizations. It could be between 2 multinational corporations. In that case, that is not a treaty, although it is an international agreement. And this reminds us, therefore, that as far as the Vienna Convention on the Law of Treaties, it focuses particularly on binding international agreements between states. And there is a requirement that it has to be in written form. And there's also a requirement, therefore, for a written agreement in order for it to be considered to be a treaty, to be governed by international law, because it is possible that you can have an international agreement between states, and yet the two states agree that it will be governed, for example, not by international law, but by the municipal law or the domestic law of a particular state. And in that case, that will not be a treaty under the Vienna Convention on the Law of Treaties. So what happens then if you have an international agreement between a state and a foreign company? In that particular case, it will be clear that that will not be a treaty under the Vienna Convention on the Law of Treaties. Now, what we need to remember is that even if you might have an international agreement between a state and a company or a private organization, so it's possible that you can have an international agreement between, let's say, the Commonwealth of Australia and maybe Microsoft, because the Australian Commonwealth government needs certain services from Microsoft. So it could be British Petroleum, or it could be an airline company. The mere fact alone that there is an agreement between a state and a foreign company would already indicate to us that international agreement, even if it is in writing, cannot be considered a treaty under the Vienna Convention on the Law of Treaties. But it does not mean that that is not an international agreement that is binding between the parties. So both parties can still be bound by that international agreement, meaning a state and a foreign company that have entered into an international agreement are still bound by that international agreement, except that it is not a treaty. And because it is not a treaty, for example, any dispute as to that particular international agreement cannot be brought before the International Court of Justice, nor can it be brought before the United Nations, for example, or any organ of the United Nations. But it has no effect at all on the binding character of such an international agreement entered into between a state and a foreign company. Because as we know, it is often the case that states do enter into international agreements with foreign companies. It could even be in terms of the supply of military weapons. So it could be the Commonwealth of Australia buying weapons, for example, from some American company, or it could be about the supply of oil, etc. In those cases, you have an international agreement that is binding, but that is not considered a treaty under the Vienna Convention on the Law of Treaties. The question then is, what law might govern that particular international agreement if it were one that was entered into between a state and a foreign company? Now, the answer is it all depends on what is stated in that particular written agreement. It could be that they would agree to submit any disputes to an international arbitration. It could be that it could be subject to the laws of the state of Australia, if it were one of the parties there, or it could be subject to the laws of the host country of a multinational company. Now, again, we will probably discuss this later on, but what this again tells us is that oftentimes a state, we will notice, actually oftentimes has two characters. One is that it has a sovereign character when it exercises certain activities. It is doing so as a sovereign or a government entity. So this could be in relation to security, it could be in relation to defense, military matters, or those which concerns the involvement of its citizens. But there is also a proprietary and even a commercial character on the part of states. And this is when states, for example, may decide to engage in trade, when a state may purchase certain equipment from another company. And in this case, the important thing to remember is that, and I think we're going to discuss this at some point, ordinarily, therefore, when a state enters into an international agreement with a private company, there is the possibility that a state may argue that because of sovereign immunity or state immunity, which is considered part of customary international law, a state, for example, may not be subject to suit or action before the courts of another country. But in relation, however, to the commercial activities of a state, customary international law acknowledges that it would be it would be up to a state, for example, to willingly allow itself to be sued in the foreign courts of, for example, of a private company that it entered into negotiations with. Because otherwise, if it were the case that a state, for example, could always plead state immunity or sovereign immunity, then there would be no reason for a private company, for example, to deal with a state if a state could never be sued. And you can have instances when a state, for example, such as Australia, may decide to lease a property, for example, in Denmark, or a property in Russia from a private company or from a private individual to use as its embassy or its consulate or some other governmental purpose. And in that particular case, there is likely to be a point where the state, in entering into such particular international agreement or contract, will indicate that it will not be invoking its sovereign immunity from suit. Now, the other point we need to be clear is that a treaty between a state and another subject of international law, such as an international organization, would be valid, but it will not be covered by the Vienna Convention on the Law of Treaties. So you can have an international agreement between, and when we talk about international organizations, we're not just talking of any international organization, we're talking about multilateral international organizations. So this could be the World Trade Organization, it could be the International Court of Justice. So these are, or it could be the United Nations Human Rights Organization. So these are the ones, when we speak of an international organization, we're talking of multilateral international governmental organizations. So these are international organizations created by states themselves. Now, so it's therefore possible that for a state to enter into a treaty with another subject of international law, such as an international organization, that particular treaty will be considered to be valid, but it will not be covered by the Vienna Convention on the Law of Treaties. So Article 3, for example, of the Vienna Convention of the Law of Treaties provides that the fact that the present convention does not apply to international agreements concluded between states and other subjects of international law, or between such other subjects of international law, or to international agreements not in written form, shall not affect the legal force of such agreements. So, what is in a name? Again, what this tells us is that under Article 2 of the 1969 Vienna Convention on the Law of Treaties, for as long as the 4 elements that we mentioned are there, whatever is the designation of the written agreement, it will be considered a treaty under the 1969 Vienna Convention on the Law of Treaties. So for as long as it is an international agreement, for as long as number 2, it is concluded between states, it is written in written form and is governed by international law, then that will be a treaty. And in that particular case, a treaty can be called a protocol, a pact, an accord, a statute, a charter, or a covenant. So you have the United Nations Charter, you have the statute of the International Court of Justice, you have the Rome Statute establishing the International Criminal Court, you have the Marrakesh Agreement establishing the World Trade Organization, you have the Kyoto Protocol, and you also have the United Nations Framework Convention on Climate Change. So do not be deceived by the nomenclature of a particular international agreement. For as long as the 4 elements of a treaty as identified under Article 2 of the 1969 Vienna Convention on the Law of Treaties are there, then that will be a treaty regardless of the particular designation of that particular written agreement. Now, what exactly, when we look at the treaties, therefore, what exactly is the nature of a treaty, and how do we know that there is a treaty? It is crucial, therefore, for a treaty to be there, that the parties must intend to create legal relations between themselves and to be bound by it. And this is a crucial point we will remember, because when you again examine international law, conventionally or traditionally, we understand that the reason why international law exists is because states agree to be bound by it. It is based on the consent of states. So states allow themselves to be bound by international law. It is not because international law is a super system of law that necessarily governs states and their interactions between them. The core basis of international law is the consent of states, mainly because, as we know, there is no super legislature out there that makes laws for states. The laws of international law are created actually by the states themselves and by their practices. So again, when we speak of treaty, the main reason why treaties have a binding character is because the parties to a treaty agree to be bound by it. And as we see later on, this raises questions as to how do we know that the states have indeed agreed to enter into legal relations? And what if one of the parties disputes that it has in fact entered into a treaty with another? And we will examine this shortly in the case of Qatar versus Bahrain, because you can have a written declaration between two states. You can have written minutes. So let's assume that there is a dispute between two states, or they're trying to attempt to arrive at an agreement for whatever reason. It could be the development of a dam. It could be a joint project for the exploration of certain lands and territories. And so what typically happens if you try to enter into a written agreement or a treaty is that there is a long process of trying to formulate in written form what the agreements are by the parties. And what happens oftentimes is that there are multiple characters from each state trying to be part of the negotiation. But how do we know that a treaty has been formed? So what if, so now we already know that the designation of a treaty, the designation of a written instrument as a treaty is not conclusive as to whether or not it is a treaty. But what if you haven't arrived yet at a point where there is in fact a final treaty, but during the course of the negotiations, the party negotiators come up with written minutes or even written agreements, minor agreements that we know will lead to a treaty? Does that preclude the conclusion of a treaty? If you only have written minutes between two states, assuming that the two states agree that they are already bound by what is written in perhaps the written minutes of a series of negotiations. So that is something which we will consider in a short while. Yep, okay. And so the other point we need to remember is that because there is a need for the parties to agree to be bound by a written agreement, and that they agree that they need to create legal relations between themselves, a mere declaration of intentions, even in written form, would not amount to a treaty. Now, this is a crucial point again, because again, without saying anything bad about China or some other superpowers, it is often common for a state to try to negotiate with another state, and then they would say, "Oh, we have arrived at an agreement that we're going to be doing this and that, and China, for example, will contribute $20 billion for the development of this and that." Okay, you probably read that in the newspapers all the time, or the United States, or it could even be Australia, makes a declaration that it will provide a donation in the amount of $200 million to let's say Malaysia or Indonesia. The question is, if that particular declaration is with the agreement of another state, does it mean that that is a treaty, and therefore Australia or China or whoever made that declaration becomes bound by what is declared in that declaration, assuming it is in written form? And it all depends on whether or not there was in fact an intention on the part of a declaring state to be bound by it. Because if it were just a mere declaration of intentions, then there wouldn't have been a binding legal obligation, and neither would there have been the development of a treaty. And so in that case, if there is no treaty, then a state which made declarations of intentions would not have violated international law if it did not follow through or if it did not fulfill its declared intentions under a written instrument. The other point we need to remember is that while a treaty might be in written form, there is no requirement as to the length, format, or a shape of a treaty. You can have a treaty that's just a one-page document, written document. You can also have a treaty that could be about 200 or even 500 pages in length. So if you examine the Marrakesh Agreement establishing the World Trade Organization, that runs to several pages, and you could have a written agreement between two states that agree on the construction, a joint construction of a dam, or the joint construction of a bridge that connects between two states. That could just be in a single document. That will not mean that that is not a treaty. It could still be a treaty, as I said, for as long as the four elements of a treaty as defined under Article 2 of the Vienna Convention on the Law of Treaties would be present. Now, that particular issue as to when legal relations might have been created was examined in the International Court of Justice in the case of Qatar versus Bahrain, which was about the maritime delimitation and territorial questions between Qatar and Bahrain. Because in this particular case, when these two states were trying to negotiate and arrive at an agreement about the delimitation of their particular territories, particularly in relation to maritime territories, they had come up with written minutes of the negotiations and the consultation between the two states. So there was no, before they arrived at a final written agreement, they wrote down in minutes, they wrote down written minutes of the consultation between the two states, and they agreed that those written minutes were already binding upon them. Because as I said, remember, as I said, when you talk about a treaty, it's always, a treaty may actually, it could take months or even years to negotiate and to finalize. And along the way, there might be changes in the negotiating panel, there might even be changes in the government. And at some point, the parties might agree to just reduce in written form any agreements they may have on certain points on a complex issue. And this is what had happened to that dispute between Qatar and Bahrain. And in this particular case, Qatar was saying that because it was just a written minute, it was obviously not denominated as a treaty, there couldn't have been a binding international agreement that amounted to a treaty, which was a source of obligations under international law. But the International Court of Justice ruled, saying it knows of no rule of international law which might preclude a joint communique from constituting an international agreement as to submit a dispute to arbitration or judicial settlement. And it cited the case of the Aegean Sea continental shelf in arriving at this particular ruling. And so in order to ascertain whether an agreement of that kind has been concluded, the court must have regard above all to its actual terms and to the particular circumstances in which it was drawn up. So in that particular case, in the case of Qatar versus Bahrain, the International Court of Justice made a ruling when the dispute was submitted by the two states to the ICJ. The ICJ made a ruling that there was in fact a treaty that was entered into by Qatar and Bahrain on the basis of the written minutes between of the consultation between the two states, mainly because the two states had agreed that in relation to the written minutes of the consultation, they were meant to be binding. The other crucial point is that under Article 102 of the United Nations Charter, it provides that every treaty and every international agreement entered into by any member of the United Nations after the present charter comes into force shall as soon as possible be registered with their secretariat and published by it. So the question is, what happens when a treaty or an international agreement between two states, for example, has not been registered with the Secretariat of the UN? Does it mean that that treaty is invalid or cannot be the source of international law obligations? Because in Article 102 of the United Nations Charter, it also provides that no party to any such treaty or international agreement which has not been registered in accordance with the provisions of paragraph 1 of this article may invoke the treaty or agreement before any organ of the United Nations. And remember, the ICJ is an organ of the United Nations. Now, that becomes problematic because, if you will recall, when we talked about Qatar versus Bahrain, the written minutes of the consultation between Qatar and Bahrain had not, in fact, been registered with the UN Secretariat, mainly because at that time that the written minutes had been entered into or drawn up by the two states. They probably were not quite clear whether there was in fact a treaty at that point. But did it mean, therefore, given the fact that the written minutes of the consultation had not been registered with the UN Secretariat, did that mean that those particular written minutes of the consultation were invalid? And the answer is no, because what it only means is that for as long as the registration has not yet been done with the UN Secretariat, it couldn't be invoked before any organ of the United Nations. But once, therefore, that particular written agreement is registered, at that point, it can then be invoked as a source of written obligation. And in this particular case, therefore, what is clear is that at the time that the dispute was brought before the International Court of Justice, the written minutes of the consultation between Qatar and Bahrain had already been registered with the UN Secretariat. So therefore, it could potentially, therefore, be invoked by either parties before the ICJ, which is an organ of the United Nations. So we've talked about already the nature of treaties, and it's also important, therefore, to know, the instances when treaties may need to be invalidated, and there are at least 6 ways by which treaties can be invalidated. So again, if you study contract law, you will notice that when you look at competence to conclude treaties, error, fraud, corruption, oftentimes these are grounds to render particular contracts to be void. Of course, because we're dealing with treaty obligations here, we're dealing with treaties in particular. Although these concepts about the invalidity of a consent may sound familiar, the rules are totally different, obviously, in international law, because the domestic systems of every country is different. So, for example, when we talk about the competence to conclude treaties, okay, hang on. So we're going to move. Okay. So when we talk about the competence to conclude treaties under Article 46(1) of the Vienna Convention on the Law of Treaties, in general, the fact that the consent of a state to be bound by a treaty has been expressed in violation of its internal law concerning competence to conclude treaties does not invalidate its consent nor the treaty. That is important because when you talk about treaties being entered into by state parties, you actually have individuals that represent particular governments or particular states. And we assume, therefore, when in the course of these negotiations that the persons who are meant to be representing a state actually have the authority of that state to enter into treaties. So on the one hand, you can have a question of whether or not that particular person has the authority to represent his particular state. But secondly, it's difficult for the other state party to a particular treaty to know what exactly are the internal laws of a particular state. Because for all we know, the internal laws or the domestic laws of a particular state may require that it has to be a particular person who can only enter into a treaty in behalf of the state. But again, as far as the internal law of a state is concerned, it is very difficult for other states to know about this. So this is the reason why under Article 46(1) of the 1969 Vienna Convention of the Law of Treaties, it provides that a state may not invoke the fact that its consent to be bound by a treaty has been expressed in violation of a provision of its internal law regarding competence to conclude treaties as invalidating its consent unless that violation was manifest and concerned a rule of internal law of fundamental importance. Now, you can also have another ground when a treaty may be invalidated would be that there is an error about an assumed fact or situation which a state assumed to exist at the time that it concluded a treaty. Now, but generally, the mere fact that there might have been an error as to a particular assumption of fact or situation, that error alone would not invalidate the consent of the state party. The only exception would be when the fact or situation which was assumed by that state to exist at the time the treaty was concluded formed an essential basis of its consent to be bound by the treaty. So let's assume that two state parties tried to enter into a treaty, again delimiting the boundaries of their respective territories. And they may have used maps, they may have used satellite imagery for that purpose. And let's assume that one of the parties alleges that there was actually an error in the map because the map was outdated, or there was an error because of a technical glitch. There was an error in the satellite imagery, and as a result, there was an error when one of the parties entered into the treaty, which that particular party may then claim to have invalidated its consent. But as should be apparent to us by now, the Vienna Convention does not lightly allow state parties to just get out of its treaty obligations. So in the two scenarios that I gave, assuming that there was an error in the map, an error in the satellite imagery concerning territorial boundaries, those types of errors would not end up invalidating the treaty because it couldn't form an essential basis of the consent of the consent to be bound by the treaty. So mere errors that do not go into the essential basis of the consent of the parties to be bound by the treaty will not invalidate a treaty obligation. The presence of fraud in the conclusion of a treaty, again, will also not of itself lead to the invalidity of a treaty. But where a negotiating state engages in a fraudulent conduct in order to induce the other state to conclude a treaty, then the latter may invoke such fraud to invalidate its consent to be bound by the treaty. So that is not problematic. Neither is this problematic corruption or coercion of a state representative. A state may also seek to invalidate its consent to be bound by a treaty if its consent has been secured through the corruption of its representative by another negotiating state, directly or indirectly, and where the representative of a state is coerced into signing a treaty through acts or threats directed against him, regardless of the author of such coercive acts or threats, then such signing shall be without any legal effect. This is an interesting point, Article 51, because some of you may be familiar with what's going on in Saudi Arabia. And I give you example, for example, of a well-known Saudi Arabian journalist dissident by the name of Jamal Khashoggi, who was killed in the Saudi Arabian embassy in Ankara, Turkey. But apart from that particular international incident, what had happened was that the president of which country was this? Was this Palestine? I can't remember now. Of Beirut, at one point was allegedly kidnapped by the Saudi Arabian authorities and held in a hotel. He actually disappeared from public view for a while. And let's assume that the president of Beirut signed an international agreement with Saudi Arabia concerning security arrangements or concerning trade. In that particular case, it would have been possible. They never entered into any treaty anyway. But had there been a treaty that was entered into between the president of Beirut and the Saudi Arabian government, then it would have been possible for Beirut to allege that the treaty was not binding in relation to Beirut because the treaty was entered into through the use of coercive acts or threats, which invalidates, therefore, the consent of one of the negotiating parties. Coercion of a state by the threat or use of force. So under Article 52 of the Vienna Convention on the Law of Treaties, where the conclusion of a treaty is procured by the threat or use of force in violation of the principles of international law embodied in the UN Charter, then the treaty shall be void. This is an interesting point for two reasons. Historically, and we know, for example, that at the time the Vienna Convention on the Law of Treaties hadn't been entered into yet by states. But you'll recall that at the end of the Second World War, when Japan surrendered to the United States, Japan gave up certain territories to become military bases of the United States. And the Japanese government also entered into a treaty with the United States whereby it undertook and committed not to engage in the development or use of nuclear weapons. And you ask the question, was there, at the time that that treaty obligation was entered into, was that based on coercion of a state or by the threat or use of force? Because, I mean, obviously, we could say that had Japan not surrendered to the United States at the time or to the Allied powers in 1945, there was always the threat that the United States would dump another atomic bomb on Japan. But I mean, that's just a question. We also need to remember as well that when it comes to the Vienna Convention on the Law of Treaties, although it is, it's a treaty, the Vienna Convention on the Law of Treaties, we also need to remember that a lot of the provisions of the Vienna Convention on the Law of Treaties is actually a codification of what is deemed to be customary international law, which means, therefore, that the mere fact that, for example, a treaty was entered into between Japan and the Allied powers at the end of World War II doesn't mean that there was nothing to govern the way that treaty obligations would be interpreted, because there are still norms of customary international law that do govern treaty obligations. And as I said, as far as the Vienna Convention of the Law of Treaties is concerned, it is considered to be a codification of customary international law. Now, the other aspect that is the source of some debate in international law is that when we talk about the threat or use of force, are we talking only of military threats? Or could a state be coerced by another state? Could one state be coerced by another state by the threat of economic or even political sanctions? So you would often hear that, if a particular state does not do this or do that, then it will restrict trade, it will blacklist certain of its state ministers, it will threaten to perhaps freeze the bank accounts of certain state officers, and for as long as they do not enter into a particular treaty. And the question is, in that particular case, can the other state invoke Article 52 on the ground that its consent has been vitiated by the threat of the use of economic sanctions? At the moment, international law recognizes that it is the threat or use of actual military force or armed force that is one that could invalidate state consent, and not the threat of economic sanctions. The other ground to invalidate a treaty obligation would be when a treaty obligation would conflict with a jus cogens norm. So a jus cogens norm is one that is so peremptory or imperative that no derogation, even by a treaty, is permitted. So there are certain norms of international law that are so peremptory, they're so imperative, they're so important that all states are required and duty bound to abide by them. And so under Article 53 of the Vienna Convention on the Law of Treaties, a jus cogens norm or peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. So you might have a treaty between two states where they agree that, they may agree to permit genocide or permit white slavery or engage in the slave trade or permit the violation of particular human rights. These particular rights are often considered to be jus cogens norms. And so therefore, if there is an international treaty that embodies certain provisions that would violate jus cogens norms, those treaty provisions would, under international law, be considered invalid under Article 53 of the Vienna Convention on the Law of Treaties. Now, when can treaties or treaty obligations be terminated and suspended? So as a rule, what we need to remember is the principle of pacta sunt servanda, which means that agreements which are legally binding must be performed. So it is a matter of general principle of international law that agreements which are legally binding must be performed, and they must be performed in good faith. Now, however, there are instances when the Vienna Convention of the Law of Treaties recognizes that there may be instances when a treaty may be validly terminated. Number one, it could be terminated by treaty provisions and consent or by denunciation. So certain particular treaties will say that even if a state has become a party to a treaty, it can still withdraw from the treaty by giving proper notice after a period of time. So that is permitted. You can also have a material breach. So if there is a party to a treaty and that particular party makes a material breach of the treaty, then in relation to the other party, that other party can cite that material breach as a ground for it not to abide by its own treaty obligations. There can also be a termination of treaty obligations on the basis of supervening events, as well as a fundamental change of circumstances under the Latin principle of Rebus Sic Stantibus, and we will consider these in a short while. So, as a rule, the termination of a treaty or the withdrawal of a party from a treaty can only take place according to the provisions of a treaty or by consent of all parties to the treaty at any time. So, if a treaty, for example, will not allow withdrawal, then in that particular case, a party to a treaty cannot just withdraw from its treaty obligations. For example, at the height of the Cold War, and you probably know about the Bay of Pigs incident, and during the Cuban Missile Crisis around 1967, for those who are in the military, and I recall easily Jack Marshall here, who would be very familiar about historical events. When I was younger, I began to wonder, why is it that the United States continues to maintain a military base in Cuba if Cuba was considered an enemy of the United States? Or why is it that the United States continued to maintain a military base in Panama? Because if you recall, in the 1980s, was it 80s or 1990s, the United States kind of invaded Panama, and they arrested the Panamanian dictator at the time, Manuel Ortega. So what the United States military did was that they just got out of the military bases in Panama, went inside Panama, which was an invasion of Panama, and then they grabbed Manuel Noriega, who was then the dictator of Panama. My point at this point is not really about the violation of international law. It's more about why was it that Panama and Cuba did not just terminate their treaty obligations with the United States, given that there was a change of government at the time that these, that a treaty was probably entered into between the United States and Panama, or treaty United States and Cuba. These were probably entered into by friendly governments, and with a change in governments, with a change of when Cuba became a communist state under Fidel Castro, why didn't Fidel Castro just terminate its treaty obligation with the United States and order the U.S. military to leave Cuban territory? But that couldn't have been done because of the requirement of Pacta sunt servanda, and because the termination of a treaty couldn't just be done. So in all likelihood, I haven't had a look at the treaty, but it could have been that Cuba, for example, gave up parts of its territory in perpetuity, which means that at no time would Cuba or Panama, for example, be permitted to take back the territory it already ceded or surrendered to the United States. And so you can have treaty obligations like that. And now, but an instance when you can have parties terminating their treaty obligations would be the case of the Rome Statute of the International Criminal Court, which creates the International Criminal Court, which provides that a state party may, by written notification, address to the Secretary General of the United Nations, withdraw from the statute. The withdrawal shall take effect 1 year after the date of the receipt of the notification, unless the notification specifies a later date. So again, a party cannot just say, I'm no longer willing to be bound by a treaty obligation. That can't happen under international law. If Cuba had suddenly said, United States, we're kicking you out of our territory, that would have been a declaration of war, and that would have allowed the United States to just invade Cuba or attack Cuba. So because that would have been a breach of international law had Cuba decided to breach its international obligations under the treaty. So denunciation. So what happens when a treaty has no provision for treaty withdrawal by a party, or for the denunciation, that is, a party makes a public avowal that it is no longer bound by the treaty, by the treaty. In this case, such a treaty is not subject to denunciation or withdrawal. So this goes back to the example I had of a treaty where Cuba or Panama gave up its territory for the United States to establish military bases, which was probably in perpetuity, unless it is established that the parties intended to admit the possibility of a denunciation or withdrawal, or a right of denunciation or withdrawal may be implied by the nature of a treaty. So once a treaty is entered into, denunciation is not going to be easy, as we clearly see under Article 56 of the Vienna Convention on the Law of Treaties, and the principle of Pacta sunt servanda, the principle of parties being required to observe their treaty obligations in good faith would be, as a matter of general principle of international law, to be observed and followed. Now, a treaty obligation for another party can also be terminated if there has been a material breach by another party. So a material breach occurs when there is a repudiation of a treaty that is not sanctioned by the VCLT, or there is a violation of a treaty provision that is essential to the fulfillment of the object or purpose of the treaty. So when one of the parties, for example, to a treaty has made a material breach, so it's not just a small, slight breach, it's a material breach of an essential treaty obligation, then the other party can consider that material breach as a ground for it to terminate the treaty or suspend its operation in whole or in part. And of course, that makes sense, right? Because if one of the parties, so let's assume that there is an agreement to enter into between two parties, two states, to enter into commercial relations, and one state may undertake and be bound and bind itself to commit to do this part, and it doesn't do it, then there is no reason why the other state should be required to fulfill its obligations. In that case, that will be considered a material breach, which under Article 60 of the Vienna Convention on the Law of Treaties can be a ground by the other party to terminate the treaty or suspend its operation in whole or in part. There can also be a termination by supervening events. So a party may find it impossible for it to perform a treaty as a result of the permanent disappearance or destruction of the object, which was crucial to the execution of the treaty. If so, such a party may validly terminate or withdraw from the treaty. And the right to terminate or withdraw from the treaty in such circumstances would only be permissible if the impossibility is not the result of a breach by that party, either of an obligation under the treaty or any other international obligation owed to any other party to the treaty. So again, that isn't a problematic provision of the Vienna Convention on the Law of Treaties. So and again, if the impossibility of performance is only temporary, then the termination of or withdrawal from the treaty would not be allowed. Instead, a party can suspend the operation of a treaty. Now, finally, you've probably heard of the principle of Rebus Sic Stantibus. And what this means is that where there has been a fundamental change of circumstances which has occurred with regard to the what happened there? So where there has been a fundamental change of circumstances which has occurred with regard to those existing at the time of the conclusion of a treaty, and which was not foreseen by the parties, there can be a Rebus Sic Stantibus situation which can permit a party to terminate or withdraw from a treaty. However, for a party to terminate or withdraw from a treaty, it must be shown that, one, the existence of those circumstances constituted an essential basis of the consent of the parties to be bound with the treaty, and two, the effect of the change is radically to transform the extent of obligations still to be performed under the treaty. Again, the crucial point is that the use of this particular provision of Rebus Sic Stantibus is frowned upon. It is an exemption to trying to get out of treaty obligations. And it is not often the case that, even if there has been a fundamental change of circumstances, that alone will mean that a party can be permitted to terminate or withdraw from a treaty. Because, as we said, there must be two things that have to be shown. One is that the existence of those circumstances constituted an essential basis of the consent of the parties to be bound with the treaty. And two, the effect of the change is radically to transform the extent of obligations still to be performed under the treaty. We can examine, the case of Hungary versus Slovakia, which involved the development of a dam project between Hungary and Czechoslovakia. At that time, there was a state known as Czechoslovakia. At some point, Czechoslovakia became, the Czech Republic, and there was also the state of Slovakia. But at that time, in 1977, there was a treaty entered into between Hungary and Czechoslovakia concerning the development of a dam, which was at the border of Hungary and Czechoslovakia. But at some point, what had happened was that the state of Hungary refused to continue to fulfill its obligations under the treaty because there had been changes that had happened in Hungary. In particular, what had happened was that several of its towns were potentially inundated, could potentially be inundated and harmed by the dam. There was also a change in the government, so that it was socialists who had come into power, and they began to question, the validity or the wisdom even of the treaty that it entered into with Czechoslovakia. And so therefore Hungary therefore tried to get out of its treaty obligations with Czechoslovakia. But the International Court of Justice ruled that Rebus Sic Stantibus conditions did not exist that would permit Hungary to terminate or withdraw from its obligations under the treaty, because while there might indeed have been a fundamental change of circumstances, because at the time, there was scientific evidence that there could be harm of the environment, and at that time there were particular international law norms concerning the obligations of states to protect the environment, and at that time there was already a groundswell of opposition on the part of the Hungarian populace to the development of a dam with Czechoslovakia. Still, the International Court of Justice ruled that those particular circumstances in the first place did not constitute an essential basis of the consent of the parties to be bound by the treaty. They were there, but they were never an essential basis of the consent of the parties to be bound by the treaty, so that even if there may have been a change in the circumstances because they had nothing to do or little to do with the state parties being bound by the treaty, then the Rebus Sic Stantibus conditions did not exist. And so therefore the International Court of Justice ruled that for Hungary to fail to fulfill its obligations under the treaty with Czechoslovakia would be a breach of international law. So under Article 62, Paragraph 2, subparagraph V of the Vienna Convention on the Law of Treaties, despite a rebus stantibus situation, a party will not be permitted to terminate or withdraw from a treaty if the fundamental change also is the result of a breach by the party invoking it, either of an obligation under the treaty or of any other international obligation owed to any other party to the treaty. So because it's possible that there might be a rebus sic stantibus because it was one of the parties that ended up changing the fundamental character of the obligations by perhaps breaching its obligations under the treaty. That does not amount to a rebus sic stantibus situation. So after having gone through this lecture podcast, after studying this topic, you should be able to discuss and explain the importance and nature of treaties, the rules that govern the various aspects of a treaty, the key provisions of the Vienna Convention on the Law of Treaties, and how states may enter into, avoid, and terminate treaty obligations. So thank you for listening to this lecture podcast, and this is Manjo Oyson. Thank you. Bye.